In essence, this process of the panel can be seen as reviewing what we have currently and also looking forward in anticipation of what could be when the Constitution is amended. The panel will outline the processes and methodology that they followed in undertaking this task, which has resulted in the report that they will present to you today. After completing their task, the panel presented their report to the President, the Interministerial Committee, as well as Cabinet. Cabinet has noted the report of the panel and referred it to the departments for analysis and identification of action plans that they will present to the IMC and then to Cabinet for adoption and execution. Cabinet has decided to publish the report of the panel for public consumption. As we speak now, the report can be sourced from our departmental website as well as the GCIS website. I also want to indicate that in presenting the report, the panel did advise us that out of the members of the panel, 2 members on some of the, or rather parts of the report, they had different perspectives, and therefore they have what they call alternative perspectives on that report. And they will, I'm informed as of yesterday, decided that they were not going to be part of today's session, but they would also make their own alternative perspective public. On behalf of Cabinet, we appreciate and thank the advisory panel for the work done and in the speed in which they've completed this task. I therefore wish to present the advisory panel to you and hand over to you, Dr. Mahlati, through the chairperson, of course, to take you through their report. Thank you.
Thank you very much. I forgot to mention the 2 other panel members that are in Cape Town.
Thank you, Honourable Minister Didiza, and Honourable Chair. Am I honourable in you now? Ms. Phumla Williams of GCIS. I also would like to recognize the acting DG of the Department of Land Reform. I'd like to recognize our members who are here with us of the panel, as indicated, Ms. Bulelwa Mabasa here, as well as Mr. Wandile Sihlobo. In Cape Town, we have both the professors, Professor Mohammed Karan, as well as Professor Ruth Hall. So they are all part of us this morning. It is with great pleasure to be here this morning after such hard work. And I just want to read the statement to give a sense of what the report that we are today talking about is focusing on. The Presidential Advisory Panel on Land Reform in Agriculture was appointed by His Excellency President Cyril Matamela Ramaphosa on 26 September 2018 to provide a unified policy perspective on land reform and independent advice to the Interministerial Committee chaired by His Excellency Deputy President David Mabuza. Panel members brought a diversity of skills, experience, as well as expertise in matters related to land reform policy, practice, and research, urban and rural development policy and planning, land reform law, agricultural economics, farming, and agribusiness. The Minister referred to the terms of reference, which cover a broad spectrum of land reform issues in rural and urban areas. We like to emphasize this because our work was not just about Section 25. We had to deal with issues that include the consideration of agrarian reform and addressing spatial inequality. The mandate was partly informed by the resolution of Parliament to consider expropriation of land without compensation. However, the panel's role is distinct from and does not duplicate the role of the Parliament's Constitutional Review Committee. Our focus has been on the circumstances in which the policy should be applied, the procedures to be followed, and the institutions to implement and enforce. Considering the complexity and the emotive nature of land reform, the panel applied evidence-based approaches, pivoting discussions and the report on historical truths and grounded facts. So there were difficult discussions amongst ourselves, but we're very disciplined in terms of nobody just says, I think and wish. It had to be evidence-based. Various reports that had diagnosed and vigorously analyzed the problems and failure of land reform were considered to build a sound basis for the recommendations that we'll be sharing with you today. As instructed by our terms of reference, these were followed up by a series of consultative processes. Within government, we met with the ministers within the Interministerial Committee as part of the 5th Administration, heads of department, Land Claims Commission, Office of the Valuer General. We also had 2 colloquia where we had included various parties from government, different spheres of government, parliamentarians, civil society, private sector, academics, legal and foreign experts. And these were followed by 10 roundtables where we specifically included various topics with different parties from these constituencies. In recognition of the magnitude of the responsibility placed on our shoulders, it was incumbent on each member of the panel to always be mindful of and hear the cries of the majority of our ancestors who were dispossessed of the land and of their birth through bloodshed and untold pain, but to also be mindful of the hopes and dreams of our future generations for a just, prosperous, stable, and egalitarian country. In essence, therefore, the premise of the work undertaken by the panel is the firm belief that land reform could enable social cohesion, deliver social justice, and restore dignity to the majority of the people of our country. We also believe that land reform can contribute to inclusive growth and sustainable development. It is thus far with great humility and pride that we are today with the Minister announcing the official approval of the report being noted by Cabinet, and this is the final report of the Presidential Advisory Panel on Land Reform and Agriculture, and the report is dated the 4th of May 2019. The Cabinet approval on 24 July 2019, which has resulted in this report being made public in Cape Town, follows the handover of the report to His Excellency President Ramaphosa, Deputy President David Mabuza, and the presentation to the 6th Administration Interministerial Committee on Land Reform. The panel wishes to emphasize and encourage each citizen and all sectors of society to read the report, not just as a policy position, but a crucial resource which will contribute to land reform, spatial transformation, and agricultural development policy formulation. The panel also expresses its gratitude and honor bestowed upon it to serve the people of South Africa. It is our hope that the recommendations contained in the report will contribute positively to expedite and sustainably deliver land reform objectives as directed by the Constitution. Before highlighting the key recommendations, it is incumbent on us to draw the public's attention to areas of disagreement which are included in the report on page 102. Our terms of reference were instructive in terms of us highlighting these areas of disagreement. These were registered primarily by Mr. Dan Creek and Mr. Nick Serfontaine. They mainly cover, but are not limited to, expropriation without compensation and amendment of the Constitution. So I will just now briefly touch on some of the recommendations, and as we look at that, we say, this is the time, Kinago. Our country has reached the precipice, we believe, and it is the hope of the panel that land reform can no longer elude us, as it forms a critical and central place within the Bill of Rights. Critical issues such as land hunger insecurity of tenure, with majority of land rights that are not legally recognized nor registered in both rural and urban areas, are threatening stability, inclusive growth, and development. The land reform trajectory requires, we believe, a radical shift, as 80% of urban dwellers, including peri-urban, reside on 2% of land, with targets for transferring commercial agricultural land 30% by 2014 not being reached, even half of that. We are informed that we are hovering around 10%. This is exacerbated by the reluctance, we believe, by government to address communal tenure and underdevelopment of communal areas, perpetuating the marginalization of women, the rural poor, and communal farmers in general. The report provides recommendations for immediate action. These include immediate allocation of land, building on and refocusing private partnerships, and strengthening of food systems and rural-urban linkages. The report further calls for a consolidated national land reform policy framework with a new white paper that addresses the current gaps to include urban land, address spatial transformation, and climate change. The framework must also add land administration as a fourth pillar, retaining and strengthening land restitution, redistribution, and tenure as indicated in 1997 National Land Policy. So, in these recommendations, the panel calls for the following: expediting and refocusing land reform to address inequality and historical injustices. South Africa has made world headlines as the most unequal country. The report attributes the persisting inequalities to the manner in which land is owned, managed, and transacted, with approaches that have not addressed historical injustices, contributing to deepening of structural poverty and inequality, particularly as far as racial, spatial, and gender is concerned. Of concern is the transactional as opposed to the transformational nature of land reform riddled with corruption. The panel's report urges the President and his cabinet to expedite the land reform process, use all its existing powers to deliver land reform, and reorient it towards meeting the most urgent needs first, to resolve the outstanding land restitution claims, to release acquired private land, state-owned land, and to much more effectively identify privately owned land needed for redistribution. The report further provides beneficiary selection guidelines to promote transparency, addressing the urgent need for human settlements, providing access to land for the landless, household food security, emerging black farmers, industrialists, and entrepreneurs. As far as land expropriation without compensation, the majority of the panel members endorsed the proposed policy shift towards using the provisions of the Constitution to expropriate land without compensation. The majority view in the panel is that it is an inescapable fact that Section 25 of the Constitution is compensation-centric. In other words, the notion and origin of expropriation draws from global examples where it is inextricably linked with some form of compensation. The panel has therefore offered a proposal for a constitutional amendment that clarifies that expropriation without compensation may be necessary in limited circumstances, and we do indicate what those circumstances are, but certainly in order to elevate the objectives of land reform. The state is already empowered under Section 25 of the Constitution to expropriate land for land reform purposes, but is required to pay just and equitable compensation. Whether and when such compensation can be at zero has been the subject of debate over the past 18 months within our country. There were differing views within the panel as to the necessity for constitutional amendment. Parliament has already voted to amend the Constitution, and a committee has been established to propose the nature of such an amendment. We have suggested some wording that would serve as a clarification that compensation may be zero in circumstances that justify this as obliged by the panel's terms of reference. The panel was further concerned about the current and previous land acquisition transactions that did not adhere to the Constitution, as it allows for expropriation with just and equitable compensation. Part of the problem was the use of the 1975 Expropriation Act that precedes 1996 Constitution, and the poor capacity of the Office of the Valuer General's Office that still uses the market value. Although the current framing of Section 25 does not inhibit the state from expropriating land, this report assists by identifying those specific conditions under which land may be expropriated without compensation. And the panel recommends that these circumstances be part of the expropriation bill and further detailed in a compensation policy. It's a motor. Excuse me. We proceed now to look at other areas, and I'll touch briefly on them. As far as land redistribution, this is an area we believe has not managed to get the right attention and priority, including resourcing by government, which forms part of the problem of failure of land reform. We propose a proactive, targeted, area-based approach. And within this, we actually indicate that land redistribution should no longer be dependent on willing buyers, willing sellers, offering the land for sale. Instead, we believe and propose that government should pursue a more proactive, targeted acquisition of land identified as needed. What is critical about this is that this offers space for integrated planning within a given area with a specific focus on understanding and analyzing the agroecological potential of the area with land use options. So the land identification and acquisition should happen at municipal level in a participatory and democratic manner to specify the land parcels required to meet the identified needs. The Constitution's property clause requires that all citizens should have access to land on an equitable basis. In our view, this requires that those who have the most urgent needs should get priority. We also propose that beneficiary selection processes be strengthened and made more transparent, consistent with the UN as well as the African Union frameworks. This should address corruption in the land allocation process, and it should assist in clarifying who should benefit. I now move to the next issue of the land acquisition. This is an important part because expropriation without compensation is also one lever and a strategy as far as land acquisition is concerned. And it is because of this that we continue to say land reform is not just equals expropriation without compensation. Expropriation without compensation is an acquisition method. So we believe that the new white paper must specify the range of land acquisition methods that will be pursued for land identified as required for land redistribution or restitution. Important as well is the call for land donations. During our process, we met as part of the consultation with various owners that include the mining houses, the churches, as well as the farmers. And the idea here was also supported by some of them who had tried to donate land but experienced problems. So we're calling now for this to be included and enabled, but with a very specific land donation policy. Part of this is also to accommodate negotiated acquisition, as well as, obviously, the expropriation, which we highlighted earlier. Now, in talking to the area of land donations, we recommend that government develop a donations policy which encourages landowners to donate properties or part of their properties by offering exemptions from donation tax and carrying the conveyancing costs of land transfer. So part of the proposal is to call on the churches, mining houses, financial institutions, agribusinesses, and others to themselves audit their own land holdings to identify land that they can donate and start the negotiations with the various government bodies. We also suggest that the minister convene within the coming year talks across these sectors to secure these donations and to open discussion with potential beneficiaries, including existing land occupiers such as farm dwellers and labor tenants. Another critical part is the financing of land reform. We have been concerned by the current budgets for land reform and recognize that government alone can never be able to address these. We require partnerships. And part of this is the proposal of the establishment of a land reform fund, which will bring together state and private finance to support land reform. Our hope is that this will get buy-in, but we need to make sure that there is broad buy-in through consultations and mobilization, and the financial support from the state, which includes restructuring of the land bank and possibly looking at incentives for private sector contribution. We also are calling on donors to also participate in this process, because it is important that people globally have to appreciate the importance of supporting this initiative for the stability of South Africa and impact on others. The restitution is one of the arms of land reform, and it has been the one that focus and resources have been applied and really focused on. The Commission on the Restitution of Land Rights, we believe, must prioritize the settlement of old order claims that were submitted by the first deadline of 31 December 1998, as required by the Constitutional Court. The Minister is urged to instruct her department to expedite claims also via redistribution, where claimants should be able to opt for land redistribution or tenure security options to avoid the onerous requirements of having to prove how and when they or their ancestors were dispossessed in the past. The Minister should also use her discretionary authority to address legitimate claims which fall outside the eligibility criteria of the Restitution of Land Rights Act, such as the Khoisan and other pre-1913 claims, via land redistribution. This means that people who were previously excluded can now be included. We recognize the need to strengthen the capacity of the Commission with additional staff and training, and call on government to do its utmost within its resources to make this happen. Critical for us is the Land Claims Court. This is a sad reality of a land claim court which 25 years on still has an acting judge. We call for the reform of the Land Claims Court. It has not performed the functions for which it was established and has not been functioning optimally and has not had one permanent judge. It should be reformed and its mandate expanded and clarified. And this includes the area of conflict resolution and mediation. To reflect this change, it should be renamed, we propose, the Land Court, to reflect its broad oversight over all land reform matters. Another critical area for us is the importance of addressing land corruption. We note with concern the growing evidence and instances of corruption in the acquisition, allocation, and transactions of land. We have identified 5 different types of land acquisition corruption, which touch across all sectors of society. We urge government to take steps to improve oversight and more investigation and prosecutions to stop land-related corruption in all its forms. The department must tighten up the beneficiary selection process to reduce the scope for corruption. Selection and allocation processes must be more transparent, and there must be greater openness and accountability as to how these decisions were arrived at. We call also on the government to establish an office of a land rights protector as an ombudsperson who can investigate allegations of corruption and, where appropriate, refer cases to the National Prosecution Authority for prosecution. In terms of farm workers and dwellers, we call for an end to farm evictions and urgently expedite mechanism to secure farm dwellers' tenure rights in line with the law. We recommend that the Minister instructs the department to urgently create an application system for farm dwellers to upgrade their tenure and expand land occupation, as provided in Section 4 of the Extension of Security of Tenure Act. When eviction applications are heard in the courts, municipalities must be required to propose on-site settlement options for farm dwellers. National government must review the farm schools policy to ensure the right to education for children residing on farms. And also the SAP system must be reformed so that illegal evictions and violations of Section 23 of ESTA are registered as criminal offences. Police, prosecutors, magistrates, and attorneys in the Land of Rights Management Facility panel all need training and mentoring by a dedicated training team emphasizing alternative dispute resolution. As far as the labor tenants are concerned, we propose that labor tenants must be a priority group to benefit from land reform. We have specifically recognized the vulnerability of particularly those located in KwaZulu-Natal and Mpumalanga, where these are black farming families already living on and farming the land. They are entitled to upgrade and secure their land rights, and we would urge government to address these issues. We call on the department to finalize the database of applications under the Land Reform Labor Tenants of 1996 and prepare a proper time-bound, costed, and publicly available plan for implementation. We call on Parliament to monitor implementation of this plan and to amend regulations to the Act to address overlapping labor tenant and restitution claims. Those whose claims have been lost must have the opportunity to resubmit and the department must identify claims where expropriation may be used to break deadlock with owners, subdividing where appropriate, and test just and equitable provisions in the Constitution to acquire and transfer this land to the claimants. Beyond these main areas, we also identified what we call game changers that can give added meaning to the land reform process and benefit a wider population. Of importance is the area of tenure reform. The panel proposes a bold new approach to recognizing and recording the diverse range of tenure rights that exist within South Africa. This, for us, is an important issue because we sit within a country where over 60% of the land rights of the population are not recognized, nor recorded or registered. Whilst apartheid laws and regulations created a racialized hierarchy of rights, we endorse the principles underpinning tenure reform in the White Paper of 1997, including legally enforceable rights based on recognizing the de facto vested rights that exist on the ground. In other words, people who by tradition are occupiers and owners of land must be recognized as such in law. We urge government to avoid private titling of communal land, which is inappropriate to customary forms of tenure, and we thus proposed a mixed tenure reform regime that recognized both private titling as well as communal. Rather, the panel recommends a land records bill which will enable the majority of citizens who hold property off register to record and register their property in order to address the issue of the estimated 60% that I referred to. These include residents of informal settlements, peri-urban areas, farm dwellers, rural communal areas, labor tenants, and others. As far as land administration, we recommend that land administration be recognized as a fourth pillar of land reform. At the heart of this is the organization of the data and alignment and reconfiguration of land administration in South Africa. Alongside restitution, redistribution, and tenure reform, we want to add land administration. This is needed to ensure that all people's land rights are well governed and administered. We call on government to appoint a working group to drive this process, set up an integrated land information system, and appoint researchers to work with state officials to identify priority testing areas, such as the areas highlighted above in terms of former homelands, informal settlements, and others, and to advise on how to scale up improved land administration. The intended outcome of these initiatives is a revitalized, integrated, and unified land administration system that provides a legal and institutional infrastructure for all land-related management and rights. Another critical part, which we believe as part of the new land reform strategy, is focus on urban land reform. We propose that land reform be extended to urban areas with the aim of building inclusive towns and cities where all residents have equitable and secure access to land for housing, businesses, recreation, and other uses. We call on government to develop an urban land reform policy and to take proactive steps to audit and redistribute well-located, vacant, underutilized, or inefficiently used urban land and buildings, including state-owned and state-leased land, that can contribute to overcoming this apartheid spatial inequality, to prioritize the social, historic, and transformative value of land over its capital asset value in decisions relating to the use, the lease, transfer and disposal of land owned by the state and state-owned enterprises. Therefore, government must respond to the growth of informal settlements and inner city occupations where land or property is already settled by recording of registrar, less formal land rights, and providing occupiers with proof of residence and providing alternative accommodation where evictions leads to homelessness, including in the form of affordable rental programs in well-located areas. Another area that we believe is critical as a game changer is focus on institutional arrangements. The issue of a capable state cannot be overemphasized in addressing land reform. The weakness within the state at all levels is part and parcel of the problems that we're experiencing. We recognize that the institutions charged with implementing land reform have faced numerous challenges, and these are long-standing problems with coordination amongst institutions. First, we propose that government should transfer responsibility of rural development away from the department. This is something that basically we feel that the department should focus on land reform, and land reform that touches on all aspects of urban and rural and different sectors as far as land use is concerned. We believe that rural development is a coordinating function and also not just a line function, because rural development involves issues of rural infrastructure, rural economies across sectors, not just agriculture. Second, we call on government to establish a land and agrarian reform agency, combining land reform and agriculture functions and directorates from the two departments. And we propose the settled restitution claims be transferred from the Commission to this agency for implementation, because there is a very complex function beyond just the transfer of land. And this is now getting into transaction advice and ensuring the use of the land. We've recognized that very often the department as well as the Commission does not have such capacity, and we believe that we need to address this to make sure that land reform succeed. So in conclusion, it must be noted that these are not all the recommendations that are contained in the report. We talk about water, we talk about climate change, we talk about access for women, and all these are contained in the report. The panel will also publish a summary of recommendations for ease of reference that will detail the sum total of all recommendations made. We look forward to engaging with the public as we assist with the implementation of the recommendations of the report through government. Thank you so much for honoring us this morning.
Thank you, Dr. At this point, we will allow questions, and I will start with Cape Town. Are there any questions from Cape Town?
Is there still Marianne? Good morning, everybody. Marianne Merton, Daily Maverick. To the Minister, first of all, in terms of the Cabinet discussions last week, is there, first of all, an overall agreement that what the panel recommended will be implemented, or is the 2-month period that was granted to various ministers to revert back a kind of waiting period to see what if and possibly pick and choosing what could be implemented? Two, we've had 2 white papers, the one correctly in 1997, but we've had a huge white paper process around about 12 years ago. That white paper process was never implemented, with the exception of the law on the valuer general. If you're now talking on another white paper policy, white paper process, excuse me, what are the time frames? What are you looking at? If I may ask the chairperson of the panel or anyone from the panel to talk a little bit wider on the communal land tenure proposals and recommendations. You stated that over 60% of South Africans live and are simply not titled in any ways and forms. We do know politically the National House of Traditional Leaders has already opposed anything except traditional leaders and traditional houses being in charge of communal areas. There are politics involved in the sense that the ANC, the governing party, has a certain liaison with traditional leaders. How do you propose that unfolds, particularly the communal land tenure rights legislation that was supposed to have been reformed over 5 years ago? Still hasn't come before Parliament. And then if you would please talk also.
You were listening there to the chairperson of the Presidential Advisory Panel on Land Reform, releasing that final land reform report finally.